This program is brought to you by Emory University.
Ladies and gentlemen, good afternoon and welcome to this Overton and Lavona Curry lecture in Law and Religion. It's a great privilege to have all of you here. Thank you so much for coming. My name is John Witte. I serve as Director of the Center for the Study of Law and Religion here at Emory University, which is the host of today's forum. Our center is dedicated to the study of religious sources and dimensions of law, politics, and society, and especially focused on inflammatory issues at the intersection of faith and freedom and family, which we'll hear about at some length today. We pursue our work through a number of cross-listed courses, degree programs, a visiting fellowship program, ongoing publications and book series, ongoing research projects, public conferences, public forums, and distinguished public lectures such as this one this afternoon. The Overton and Lavona Curry Lecture in Law and Religion is our oldest and our most distinguished forum offered under the aegis of our Law and Religion Center. Prior Curry lecturers who have graced this lectern include Archbishop Desmond Tutu, Judge John T. Noonan Jr., Professor Stephen Carter from Yale, Professor Robert Bella from Berkeley, Professor Martin Marty from Chicago, President Rebecca Chop from Swarthmore, Bishop Gene Robinson, and a number of other public intellectuals and scholars of world significance. This lecture series is made possible by a generous grant and gift from Mr. Overton and Mrs. Lavona Curry. Mr. Curry was a brilliant construction lawyer and a graduate of Candler School of Theology, but who spent his time working on God and mammon together in the legal profession, which he did with enormous sophistication and enormous success. And he, out of his passionate interest in law and religion, together with the interests of his bride, Lavona, chose to establish an endowment in support of this lecture series. And it has provided an ideal forum for discussion of some of the weightier matters of the law that deeply occupied both of Overton and Lavona. We have the privilege of welcoming today Mrs. Curry, who represents the Curry family and represents her late great husband Overton, and we have a number of other members of the Curry family who are with us, and I think it only apt, at the risk of embarrassing them, to ask them to stand to receive our applause of appreciation for their support for what we're doing. We have the privilege today of welcoming to the Curry Lectern my distinguished brother and friend and colleague, Professor Michael J. Perry. Professor Perry is one of the world's great authorities on issues of law, religion, and morality. He was educated at Georgetown University and Columbia Law School. He has taught and lectured around the world with notable appointments at Yale Law School, at Northwestern University, at Wake Forest University, University of San Diego, Tokyo University, and a number of other distinguished institutes and schools around the world. He is our Robert W. Woodruff Professor of Law here, and with the death of our distinguished colleague and teacher, Professor Harold J. Berman, he has now ascended to be the senior guru in law and religion at Emory University and is the teacher of us all. His work is wide in its scope and deep in its scholarship and deeply influential in its import. He has published some 75 articles and 11 books. Everyone will have their favorite Curry titles. Go to the Cambridge University Press or Oxford University Press website, and you can download a half a dozen at each place. Amongst my favorites are his book, Love and Power, one of his early deep disquisitions on issues of authority and liberty and law and religion. His work on the idea of human rights, his Toward a Theory of Human Rights, his work on Under God, the place of religion and liberal polities, issues of political morality in liberal democracies. He's now working on questions of the morality of constitutionalism, the morality of human rights, on which he has written with enormous acuity. Professor Perry has, amongst the various topics that have occupied him deeply, tried to help us navigate the contested terrain at the intersection of religious freedom and sexual liberty and privacy and autonomy norms. And that is a place where he has made exquisite contributions in the last 15-odd years of his scholarship, and a place where he has complicated the discourse in a way that allows us to get beyond simple bumper sticker reflections, political platitudes, and simple reflexive ideologies, and to think hard about what is at stake in the question of sexual liberty and privacy and autonomy on the one hand, and the rights of individuals and groups to practice their religious freedom consistent with their conscience, thought, and belief. On those matters, Professor Perry really in many ways is the best in the world, and he has written with enormous acuity and power and helped us come to an understanding, I think, that is more responsible to the stakes involved in this discourse. We are going to have the privilege of listening to him in that of one of his many areas, but in that area of distinctive, unique strength this afternoon in his lecture on religious freedom, same-sex marriage, and the Catholic Church. I hope that you will join me with a robust round of applause to welcome my distinguished friend, my teacher, my colleague, my brother, and the teacher of us all, as we'll hear today, Professor Michael J. Perry.
Well, I am certainly grateful to John for his wonderfully affirming introduction. And I am grateful to all of you for taking the time to be here this afternoon. As you've surely noticed, contraception, religious freedom, and the Catholic bishops have been back in the news recently. Back in the news, that is, as part of a single story. And I say back in the news because contraception, religious freedom, and the Catholic bishops were in the news as part of a single story some 50 years ago. Today, the bishops are complaining that a policy they oppose, a policy concerning contraception, compromises their religious freedom. 50 years ago, a policy the bishops supported, a policy concerning contraception, violated the religious freedom of others. Today, the bishops are quite vocal in telling us how, in their view, the policy they oppose violates their religious freedom. 50 years ago, the bishops needed to be persuaded that the policy they supported, a legal ban on the distribution and use of contraceptives, violated the religious freedom of others. The celebrated American Jesuit John Courtney Murray, in a memo to Boston's Cardinal Cushing, explained why the cardinal should no longer oppose the Massachusetts legislature's proposal to remove the legal ban on contraceptives. Father Murray wrote in a then private memo to Cardinal Cushing. He said, "The practice, contraception, undertaken in the interests of responsible parenthood, has received official sanction by many religious groups within the community. It is difficult to see how the state can forbid, as contrary to public morality, a practice that numerous religious leaders approve as morally right. The stand taken by these religious groups may be lamentable from the Catholic moral point of view, but it is decisive from the point of view of law and jurisprudence that that so many numerous religious leaders were approving of contraception." Now, when Murray said that was decisive from the point of view of law and jurisprudence, he didn't elaborate what he meant by law and jurisprudence. My lecture today aims to supply the missing elaboration, but it does so not in the context of the controversy over the morality of contraception, which is no longer a live issue for most of us, including most Catholics in the United States. My lecture today aims to supply the missing elaboration in the context of the controversy over the morality of same-sex marriage. Now, I'll be a bit more precise than Murray was. What Murray said was decisive from the point of view of law and jurisprudence is decisive, as I will explain, from the point of view of the right to religious and moral freedom. So let me begin by elaborating the right to religious and moral freedom, which is internationally recognized as a human right. The articulation of the right that we find in the International Covenant on Civil and Political Rights is canonical in this sense. The great majority of the countries of the world, over 85%, are parties to the covenant. As of this month, 167 of the 195 countries that are members of the United Nations are parties to the covenant, including, since 1992, the United States. Article 18 of the covenant states, in relevant part, "Everyone shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice, and freedom, either individually or in community with others, and in public or private, to manifest his religion or belief in worship, practice, observance, practice, and teaching." Article 18 continues, "Freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others," says Article 18. The United Nations Human Rights Committee, the body that monitors compliance with the covenant, and under the first optional protocol to the covenant, adjudicates cases brought by individuals alleging that a state party is in violation of the covenant. The UN Human Rights Committee has stated that, quote, "The right to freedom of thought, conscience, and religion in Article 18.1 is far-reaching and profound." Well, how far-reaching and profound? Note the breadth of the right that, according to Article 18, everyone shall have. It's the right to freedom not just of religion, but of conscience. The right shall include freedom to have or adopt a religion or belief of his choice, and freedom, either individually or in community with others, and in public or private, to manifest his religion or belief in worship, observance, practice, and teaching. Article 18 explicitly indicates that the right concerns moral as well as religious freedom. Article 18 explicitly identifies the belief that is protected as moral belief when it states that, and I quote Article 18, "The state parties to the covenant undertake to have respect for the liberty of parents and, when applicable, legal guardians, to assure the religious and moral education of their children in conformity with their own convictions." So the right we're discussing protects not only freedom to practice one's religion, including, of course, one's religiously based morality, it also protects freedom to practice one's morality, freedom to, quote, "manifest his belief in practice," even if one's morality is not embedded in a religious tradition. Even if, that is, one's morality is embedded not in a transcendent worldview, but in a worldview that is not transcendent. And by a transcendent worldview, I mean simply a worldview that affirms rather than denies or is agnostic about the existence of a transcendent reality as distinct from the reality that is or could be the object of natural scientific inquiry. As the Human Rights Committee has put the point, and I quote the committee draws the attention of states parties to the fact that the freedom of thought and the freedom of conscience are protected equally with the freedom of religion and belief. Article 18 protects theistic, non-theistic, and atheistic beliefs as well as the right not to profess any religion or belief. The terms belief and religion are to be broadly construed, says the committee. Article 18 is not limited in its application to traditional religions or to religions and beliefs with institutional characteristics or practices analogous to those of traditional religions. And in fact, in deriving the right to conscientious objection from Article 18, the Human Rights Committee explained that, quote, the legal obligation to use lethal force may seriously conflict with the freedom of conscience and the right to manifest one's religion or belief, and emphasized, quote, there shall be no differentiation among conscientious objectors on the basis of the nature of their particular beliefs. Now, our neighbor to the north, Canada, the Canadian Supreme Court has emphasized that the right to religious and moral freedom is a broad right that protects freedom to practice one's morality without regard to whether one's morality is religiously based. Referring to Section 2A of the Canadian Charter of Rights and Freedoms, which states that everyone has freedom of conscience and religion, the Canadian Supreme Court explained the purpose of Section 2A is to ensure that society does not interfere with profoundly personal beliefs that govern one's perception of oneself, humankind, nature, and in some cases, a higher or different order of being. These beliefs in turn govern one's practices, said the court. According to the Canadian Supreme Court, Section 2A, quote, means that, subject to certain limitations, no one is to be forced to act in a way contrary to his beliefs or his conscience. Religious and moral freedom, as the Canadian Supreme Court explained, is the freedom to live one's life in harmony with one's most fundamental convictions and commitments. Specifically, those that are the yield of one's response to what are sometimes called ultimate questions, such as, who are we? Where did we come from? What is our origin, our beginning? Where are we going? What is our destiny, our end? What is the meaning of suffering, of evil, of death? And there is the cardinal question, the question that comprises many of the others. Is human life ultimately meaningful, or instead ultimately bereft of meaning, meaningless, absurd? If any questions are fundamental, these questions, what the narrator in Milan Kundera's The Unbearable Lightness of Being refers to as naive questions, questions with no answers, barriers that cannot be breached. These are, says the eminent Catholic theologian David Tracy, the most serious and difficult that any human being or society must face. Tracy memorably calls these religious or limit questions. And I'll return to that phrase later in my lecture. These ultimate questions, Tracy says, religious or limit questions. And one's answer to such questions obviously bears strongly on this fundamental question: what sort of life is constitutive of or conducive to one's religious, or if you prefer, spiritual, and our moral well-being? I say religious and our moral well-being as opposed to physical and psychological well-being. I'll return to that distinction. Historically extended communities, traditions, are principal matrices of answers to such religious or limit questions. Of course, those who struggle with religious or limit questions, such as the question, does God exist, do not invariably end up giving answers that constitute a transcendent worldview. To the contrary, many end up giving answers that constitute a thoroughgoing rejection of any transcendent worldview. Nonetheless, John Paul II was surely right in his encyclical Fides et Ratio that such questions, quote, have their common source in the quest for meaning which has always compelled the human heart, and that, he said, the answer given to these questions decides the direction which people seek to give to their lives. Some covenant rights, such as the Article 7 right not to be subjected to torture or to cruel, inhuman, or degrading treatment or punishment, some covenant rights are unconditional, absolute. They forbid or require government to do something, period. But some other covenant rights, by contrast, are conditional. They forbid or require government to do something unless certain conditions are satisfied. Article 18 is a right of articulates a right of the latter sort. It makes clear that under the right to religious and moral freedom, government may not ban or otherwise impede a practice protected by the right unless each of three conditions is satisfied. First, the legitimacy condition. The ban or other policy must serve a legitimate government interest. Two, the least burdensome alternative condition. If the policy serves a legitimate government interest, the policy must be necessary to serve that interest in the sense that the policy serves that interest significantly better than would any policy less burdensome to the protected practice. And third and finally, the proportionality condition. What the policy achieves in serving that interest, the benefit of the policy, must be sufficiently weighty to be proportionate to the disadvantage the policy visits on those subject to the policy, the cost of the policy. The relationship between the human rights Grundnorm, the fundamental human rights norm, articulated in Article 1 of the Universal Declaration of Human Rights, that, quote, all human beings are to act towards one another in a spirit of brotherhood. The relationship between that human rights Grundnorm and the right to religious and moral freedom is clear. To prevent persons from living their lives in harmony with their most fundamental convictions and commitments, or to make it significantly more difficult for them to do so, is hurtful to them, sometimes greatly hurtful. The countries of the world, the great majority of them, agree that for a government to cause anyone such hurt is not for it to treat him in a spirit of brotherhood, unless the law or other policy that is the source of such hurt satisfies each of the three conditions: legitimacy, least burdensome alternative, and proportionality. Again, the right to religious and moral freedom is not, as a practical matter, it cannot be, unconditional. What government interests are not legitimate under the right to religious and moral freedom? Article 18 does not call into question the legitimacy of governments acting to protect, to list just the most obvious examples, the lives, health, safety, liberty, property, or socioeconomic well-being of the citizenry and other human beings. It doesn't call into question government's legitimate concern with the orderly functioning of society, including the orderly functioning of democratic and judicial processes. It doesn't call into question the legitimacy of government's concern with human rights, with non-human animals, with the environment. Article 18 allows for government to protect even, quote, the public morals. However, as the Human Rights Committee has emphasized, the scope of a limitation referred to in the covenant shall not be interpreted so as to jeopardize the essence of the right concerned. All limitations clauses shall be interpreted strictly and in favor of the rights at issue. All limitations shall be interpreted in the light and context of the particular right concerned. So, with respect to the public morals, the Human Rights Committee has emphasized, quote, the concept of morals derives from many social, philosophical, and religious traditions. Consequently, limitations on freedom to manifest a religion or belief for the purpose of protecting morals must be based on principles not deriving exclusively from a single tradition. A single tradition? Recall that, as the committee explained, Article 18 protects theistic, non-theistic, and atheistic beliefs, as well as the right not to profess any religion or belief. Article 18 is not limited in its application to traditional religions or to religions and beliefs with institutional characteristics or practices analogous to those of traditional religions. The committee has also declared that if a set of beliefs is treated as official ideology in constitutions, statutes, proclamations of ruling parties, etc., or in actual practice, this shall not result in any impairment of the freedoms under Article 18 or any other rights recognized under the covenant, nor in any discrimination against persons who do not accept the official ideology or who oppose it. And as the editors of a casebook on the covenant have put the point, in commenting on the Human Rights Committee's several statements about the right to religious and moral freedom, they say, public morals measures should reflect a pluralistic view of society rather than a single religious culture. As the Human Rights Committee's statements make clear, I think, government's pursuit of certain interests is fundamentally inconsistent with the right to religious and moral freedom. And to affirm the right to religious and moral freedom is necessarily to hold, therefore, that government may not pursue those interests, that under the right to religious and moral freedom, those interests are not legitimate government interests. Recall the committee saying, the scope of a limitation referred to in the covenant shall not be interpreted so as to jeopardize the essence of the right concerned. What interests are fundamentally inconsistent with the right to religious and moral freedom? The general answer, I submit, no interest is a legitimate government interest if, in pursuing that interest, government is acting as an arbiter of one or more religious or limit questions, such as, does God exist? Is Jesus the Son of God? Is behavior X contrary to the will of God? As I explain in the work from which this lecture is drawn, the right to religious and moral freedom is the yield mainly of two insights. First, the profound insight based on historical experience that governments, including democratic governments and the political majorities they represent or purport to represent, should not be trusted as arbiters of true answers to religious or limit questions. Governments are stupefyingly incompetent to answer such questions. The second insight, which like the first is based on historical experience, is the insight that given the suffering it causes and the divisiveness it precipitates, the coercive imposition of answers to such questions is more likely to corrode than to nurture the strength of a society, especially a society that, like ours, is a religiously and morally pluralistic democracy. All citizens, believers of every stripe and non-believers, have the same basic reason to insist that government not ban or otherwise impede a practice protected by the right to religious and moral freedom unless all three conditions, legitimacy, least burdensome alternative, and proportionality, are satisfied. For government to ban or otherwise impede a practice protected by the right to religious and moral freedom, again, if one or more of the three conditions are not satisfied, is for government to fail to treat those whose practice is impeded in a spirit of brotherhood. Now, let's turn to the same-sex marriage controversy against that background. As most of you know, in the United States, it is the states individually, not the federal government, that gets to determine, subject to federal constitutional limits, which couples may have access to civil marriage. I now want to illustrate the force of the right to religious and moral freedom, specifically the force of the legitimacy condition, by inquiring whether a state's denial of access to civil marriage to same-sex couples, let us call that denial the non-recognition policy, whether that policy violates the right to religious and moral freedom. Again, the right to religious and moral freedom protects one's freedom to live one's life in harmony with one's most fundamental convictions and commitments, those that are the yield of one's response to religious or limit questions, including what sort of life is constitutive of or conducive to my religious and our moral well-being. A law or other policy that prevents one from living such a life implicates the right to religious and moral freedom. Implicates. Because the desire to live together with another person in an officially recognized marriage is, for most persons, animated at least in part by one's most fundamental convictions and commitments. And because the non-recognition policy prevents a same-sex couple from living together in such a marriage, the policy implicates the right to religious and moral freedom. But that the policy implicates the right doesn't entail that the policy violates the right. The policy violates the right if it does not serve a legitimate government interest. Does the non-recognition policy serve one or more legitimate government interests? In the United States, the government interests that have been offered in support of the non-recognition policy are of two sorts, which I call morality-based and non-morality-based. By a morality-based government interest, I mean an interest whose pursuit by government is based on the view that same-sex sexual conduct is immoral. By a non-morality-based government interest, I mean one whose pursuit by government does not presuppose that same-sex sexual conduct is immoral. In the United States and other liberal democracies, the dominant rationale for the non-recognition policy, as is well known, involves a morality-based government interest to this effect. Granting access to civil marriage to same-sex couples would tend to legitimize, normalize, and even incentivize same-sex sexual conduct. This we must not do. Same-sex sexual conduct is immoral. For example, in 2003, the Vatican, specifically the Congregation for the Doctrine of the Faith, whose prefect at the time was Joseph Cardinal Ratzinger, now Pope Benedict XVI, emphasized that granting access to civil marriage to same-sex couples would signal, quote, the approval of deviant behavior with the consequences of making it a model in present-day society, close quote. Denying access to civil marriage to same-sex couples obviously serves the government interest in not taking a step that would tend to legitimize conduct believed by many to be immoral, same-sex sexual conduct. The serious question is whether that government interest, that morality-based government interest, qualifies as a legitimate government interest. The answer depends on the reason or reasons lawmakers have for believing that same-sex sexual conduct is immoral. If the only reason they have for that moral belief is that such conduct is, quote, in direct opposition to God's truth as he has revealed it in the scriptures, close quote, then the government interest is plainly not legitimate. As I explained earlier in this lecture, in determining whether a law or other policy is consistent with the right to religious and moral freedom, no interest is a legitimate interest if in pursuing that interest, government is acting as an arbiter of religious or limit questions, such as the question whether same-sex sexual conduct is contrary to the will of God. However, that same-sex sexual conduct is contrary to the will of God is not the only reason lawmakers have for believing such conduct to be immoral. Indeed, the path of reasoning runs in the opposite direction for many religious believers, whose position is not that because it is contrary to the will of God, same-sex sexual conduct is immoral, but that because it is immoral, same-sex sexual conduct is contrary to the will of God. What other reasons do lawmakers have? In particular, what non-theological reasons do they have for believing that same-sex sexual conduct is immoral? The Pope and bishops of the Roman Catholic Church, the magisterium of the Church, are leading opponents of, quote, legislative and judicial attempts, both at state and federal levels, to grant same-sex unions the equivalent status and rights of marriage by naming them marriage, civil unions, or by other means. According to the magisterium, it is immoral not just for same-sex couples, but for anyone and everyone, even a man and a woman who are married to one another, to engage in any sexual conduct that is inherently non-procreative. And same-sex sexual conduct, like contracepted male-female sexual intercourse and every act of masturbation, oral sex, and anal sex, is inherently non-procreative. The U.S. Conference of Catholic Bishops state that because what are called homosexual unions are inherently non-procreative, their language, declared the Administrative Committee of the U.S. Conference of Catholic Bishops, they cannot be given the status of marriage. As Joseph Cardinal Ratzinger stated in 2003, speaking for the Congregation for the Doctrine of the Faith, because such unions, such conduct, closes the sexual act to the gift of life, homosexual acts go against the natural moral law. The obvious question, why is it immoral to engage in any sexual conduct that is inherently non-procreative? The magisterium's answer, engaging in such conduct is subversive of, it is hostile to, it constitutes an attack, an assault on one's authentic well-being, welfare, eudaimonia, flourishing. To what aspect of human well-being might one be referring, or to use a more common term, health, to what aspect of human health might one be referring in claiming that engaging in inherently non-procreative sexual conduct is hostile to one's well-being? Human health includes, of course, psychological health as well as physical health. And the psychological health of the citizenry, no less than its physical health, is widely and understandably thought to be a legitimate government concern. Indeed, we have learned and are still learning that with respect to many illnesses, such as clinical depression, the line between the physical and the psychological is far from clear. Bans on the use of some addictive substances, such as heroin, are best understood as aimed at least partly at protecting psychological health, as are bans on prostitution. A quote from a study: "The ways prostitution harms those working as prostitutes are deep and pervasive. Prostitutes typically suffer economically, physically, and emotionally from prostitution. They rarely find economic success and experience deep and lasting psychological harm that retards their ability to form healthy, lasting, intimate relationships," close quote. However, that sexual conduct is inherently non-procreative does not make engaging in such conduct hostile either to one's physical health or to one's psychological health. It would be ridiculous to say of couples whose sexual intimacy includes inherently non-procreative sexual conduct, of a contraceptive, for example, that they, quote, "typically suffer physically and emotionally from engaging in that conduct. They experience deep and lasting psychological harm that retards their ability to form healthy, lasting, intimate relationships." If not to physical health or psychological health, then, to what other kind of health, to what other aspect of human well-being might one be referring in claiming that engaging in inherently non-procreative sexual conduct is hostile to one's health? One's religious health? Well, the magisterium of the Church and others who say the same thing specifically deny that their argument is religious. In any event, if under the right to religious and moral freedom, protecting the religious health of the citizenry were a legitimate government interest, the right would be largely meaningless. Government could ban a practice protected by the right whenever it judged the practice to be seriously detrimental to the religious health of those who engage in the practice. You can imagine someone saying, well, practicing a false religion, namely any religion that denies that Jesus Christ is the Son of God and the Lord and Savior of all, is profoundly detrimental to one's religious health. Again, to what kind of health, if not physical, psychological, or religious, might one be referring? The only other possibility that comes to mind is moral health, moral well-being. And indeed, the magisterium is best understood as claiming that engaging in inherently non-procreative sexual conduct is hostile to one's moral health. That claim, however, is no more availing under the right to religious and moral freedom than the claim that engaging in such conduct is hostile to one's religious health. Recall that the right to religious and moral freedom is broad. The right protects not only practices that, for the persons engaging in them, are embedded in a transcendent worldview, but also practices that, for the persons engaging in them, are embedded in a worldview that is not transcendent. If under the right to religious and moral freedom, protecting the moral health of the citizenry were a legitimate government interest, the right would be largely meaningless. Government could ban a practice protected by the right whenever it judged the practice to be seriously detrimental to the moral health, the moral well-being of those who engage in the practice. You could imagine someone saying, oral sex is profoundly detrimental to one's moral health. Again, in determining whether a law or other policy is consistent with the right to religious and moral freedom, no interest is a legitimate government interest if in pursuing that interest, government is acting as an arbiter of religious or limit questions. One such question, as I noted earlier, what sort of life is constitutive of or conducive to one's religious and our moral well-being, as distinct from one's physical and psychological well-being? Whether engaging in what the Administrative Conference of the U.S. Conference of Catholic Bishops has called inherently non-procreative sexual conduct is hostile to one's moral health is obviously a variation on that question. As such, the question whether engaging in inherently non-procreative sexual conduct is hostile to one's moral health, a question that's disputed, it bears emphasis, even just among Catholic moral theologians, not to mention the larger community of religious ethicists, is not one that the political powers that be, under the right to religious and moral freedom, may answer. As I said, denying access to civil marriage to same-sex couples obviously serves the government interest in not taking a step that would tend to legitimize conduct believed by many to be immoral, same-sex sexual conduct. The serious question is whether that morality-based government interest qualifies under the right to religious and moral freedom as a legitimate government interest. The answer, again, depends on the reason or reasons lawmakers have for believing that same-sex sexual conduct is immoral. If they have a reason other than the two referenced here, the contrary to God's will reason and the hostile to moral health reason, I don't know what it is. That is to say, if they have another morality-based government interest, I don't know what it is. There remains the possibility that the non-recognition policy is warranted by one or more non-morality-based government interests. One or more interests, that is, whose pursuit by government does not presuppose that same-sex sexual conduct is immoral. The principal such interests offered by supporters of that policy are two: protecting the welfare of children, protecting the institution of traditional opposite-sex marriage. Both are undeniably legitimate and even compelling, weighty government interests. But as others have offered at length, have explained at length, and there's no need for me or time to belabor the point here, no credible argument supports the claim that denying access to civil marriage to same-sex couples serves either of those two legitimate government interests. Put another way, no credible argument supports the claim that all the countries such as Canada and the states that have thus far granted access to civil marriage to same-sex couples have thereby disserved, imperiled, either the welfare of children or the institution of marriage, or both. Indeed, denying access to civil marriage to same-sex couples disserves, and granting access to civil marriage to same-sex couples serves the welfare of those many children who are now being raised by same-sex couples. And let me say in conclusion that at the beginning of this lecture, I observed that today the Catholic bishops in the United States are complaining that a policy they oppose, a policy concerning contraception, violates their right to religious and moral freedom. I also observed that 50 years ago, a policy the bishops supported, a policy concerning contraception, violated the religious and moral freedom of others. In my lecture today, speaking, I hope, in the spirit of American Jesuit John Courtney Murray, I have explained why another policy the bishops support, the exclusion of same-sex couples from civil marriage, violates the religious and moral freedom of others. It is fitting, of course, that the bishops are concerned about policies that, in their judgment, compromise their right to religious and moral freedom. But it is important that the bishops not support policies that violate the religious and moral freedom of others. Now, in the work from which this lecture is drawn, I address two further related questions. Whether the right to religious and moral freedom is a part of the constitutional law of the United States, and if so, whether the Supreme Court of the United States should rule that the non-recognition policy is unconstitutional. I've said nothing about either of those two interesting questions in this lecture. And if some of you are interested in reading what I have to say in response to those two questions, please just send me an email. So let me close by thanking you all again very much for taking the time to be here this afternoon.
Well done, our teacher. We have a nice 15 minutes or so to address questions about these hard and controversial issues. We have a world authority to answer your questions, and may I invite you to avail yourself of the two microphones in the center of the auditorium if you are blocked in your seat, or if you prefer to have the microphone brought to you, please just raise your hand and we'll do so. But may I invite questions? Speeches, let's leave, but if you have pithy questions to put to our speaker about this important topic, please, may I invite those? Reticence has never been one of the marks of Emory law students or Emory community members, but let me start with a question and just to get us started, and then that will hopefully prime the pump for better questions. Professor Perry, my dear friend, what do you do with two fundamental rights claims based on freedom and morality? The rights of the Catholic Church to maintain its own internal ecclesiastical discipline and moral standards for members of its community, which is manifest in its exclusion of consecration for same-sex couples in their midst, and the moral and religious freedom right of individuals that you properly point out protects their right to be married. How do you balance those two fundamental rights claims, each rooted in Article 18 norms? How would you, sage that you are, work out that dialectic?
Well, I hope it was obvious. I was talking about access to civil marriage. And in other words, access to the marriage that the state creates, the institution the state creates, civil marriage. I'm not aware of anyone who participates in this controversy who has hinted or suggested that there is any interest, or if there were an interest, it would be constitutional to try to require a religious community to embody in its practices a different understanding of marriage. What they would think of as a countercultural, in 50 years perhaps, they will think of as a countercultural understanding of marriage. So if the Catholic Church wants to insist that marriage must be between a man and a woman, some of you are aware that Timothy Radcliffe is going to be speaking here next week, the former Master General of the Dominican Order. Timothy Radcliffe was recently in a publication in London called The Tablet. It was one of three voices commenting on the same-sex marriage controversy. And he said it is the position of the Catholic Church that it's simply impossible for two persons of the same sex to be married because marriage is essentially between a man and a woman. It's a question of impossibility, according to the Catholic Church. Well, nothing I have said today or at any other time calls into question the constitutionally protected and human rights protected right of the Catholic Church to order its life among its members according to its understanding of marriage. That's not at stake. What's at stake is access to civil marriage. Now, there is, as John knows better than I do, John is the resident expert on constitutional issues regarding religious liberty. There is some concern on the part of religious institutions, including the Catholic Church, about whether when they participate in public activities such as adoption services or running hospitals, that's very much in the news, right? To what extent they're going to be required to recognize that which the law recognizes. So, for example, let's assume that a same-sex couple, a member of a same-sex couple, is working for a Catholic hospital and says that just as my male friend's wife is the beneficiary of his insurance policy, I want my same-sex partner to be the beneficiary of my insurance policy. And let's say the Catholic hospital says, well, we can't do that because we just don't recognize your marriage. Those are going to be interesting and difficult and challenging issues. But I of course, said nothing about that in my lecture. And but those are the sorts of religious liberty issues that are on the horizon, not the issue of whether the church is going to be permitted to live by its own sacramental understanding of marriage. We're talking about access to civil marriage.
Oh, okay. Let's make sure it's working.
I have to ask you to translate the question.
I wanted to ask, why is it more of advocating against gay marriage, but you don't see any the church advocating against remarriage and divorce to the same extent? Because in Mark 10:9 it says, "Therefore God has joined together; no human must separate." And that to remarry and divorce would be adultery. And I could see the argument of protecting children if you were to advocate against divorce or remarriage. But because of that, does it focus more about the procreation aspect? Is that what's the most important then, if they're not advocating against other forms of marriage?
The church has different reasons for opposing different laws and policies. The heart of its opposition to granting access to civil marriage to same-sex couples is its view that inherently non-procreative sexual conduct is immoral. That's the heart of its view with respect to that issue. And notice, this is not a position specifically about homosexual conduct. It's a position about inherently non-procreative sexual conduct, and that includes homosexual sexual conduct. But this is essentially the church's position about contraception, masturbation, and a whole variety of activities. The church's opposition to divorce had nothing to do with its position about the immorality of inherently non-procreative sexual conduct. It had to do with its view about the indissolubility of a genuine marriage. And if your question, perhaps I've misunderstood you, but if your question is, why don't we hear as much from the U.S. Conference of Catholic Bishops about divorce, which some would say is much more threatening to the institution of marriage than admitting same-sex couples to civil marriage, the answer is because that battle was lost. And what some lay defenders and elaborators of the bishop's position, such as Robert George, professor in the Department of Politics at Princeton University, will say is that, yes, divorce was terrible in terms of its consequences for marriage, is terrible, widespread access of divorce for its consequences for marriage. But there's not a lot we can do about that now. We don't want to we don't want to do this next thing, granting same-sex couples access to civil marriage, which in its own way will also be very harmful for the institution of traditional marriage. Now, in my talk, I have nothing of value to add to the part of the discussion concerning the welfare of children or the importance of the institution of traditional marriage as reasons not to grant access to civil marriage to same-sex couples. There's a huge literature addressing that argument to and fro, and in my judgment, as I reported in the piece, but it's merely an assertion in my lecture, but I'm happy to guide anyone, to point anyone to the literature. In my judgment, there is simply no credible argument along those lines that the welfare of children will be imperiled or that the institution of traditional marriage will be imperiled. In fact, my own view is that no one who doesn't take seriously the morality-based argument for excluding same-sex couples from civil marriage is likely to put much weight on those reasons. Those reasons I tend to look at as kind of post hoc rationalizations for wanting to keep same-sex couples out of civil marriage, post hoc rationalizations on the part of people who are wary about saying that their fundamental reason is that same-sex sexual conduct is itself immoral.
It seems that you're saying that there's no compelling state interest for banning homosexual marriage. I was wondering what your views were on whether there is a compelling state interest on banning polygamy, because those arguments seem pretty similar as far as morality and religious health.
That's a great question. Let me just say that my argument didn't have to do with whether the government interest was compelling or not. We'd be talking in those terms if we got down to the issue of proportionality. How weighty is the government interest given the cost of the regulation? I was saying that the government interest is not legitimate, the particular interest that I was talking about. And since if I'm right, and since the first of the three conditions is not satisfied, we don't even get to the second and third conditions. Polygamy. A Canadian court within the last few months finally decided a case in which it had been argued that the Canadian ban on polygamy, by the way, understand that when we talk about the refusal to admit same-sex couples to civil marriage, we're not talking about a ban on same-sex marriage. The state is not trying to punish people who say, or even whose religious community say, they're married, same-sex couples. They can do that. We're talking about the state denying access to civil marriage to same-sex couples, not banning. But in the case of polygamy, typically what we have is a ban on polygamous relationships. And the Canadian ban on polygamous relationships was before the Canadian courts recently, and the argument was being made that that ban fell short of the Canada's right to various constitutional rights, including the right to religious freedom. And the Canadian Supreme Court, not the Canadian Supreme Court, it wasn't a Supreme Court case, but the Canadian court decided that many of the non-morality-based government interests were, in fact, legitimate interests and sufficiently weighty to warrant the ban. And so in the opinion, you see a discussion about the consequences of polygamous relationships for women, in particular young women, for children, and others. So the feeling of the Canadian court was that there were, in fact, whether one agrees ultimately with it or not is a separate issue, but the feeling of the judgment of the Canadian court was that there was a serious non-morality-based case to be made for the ban on polygamy, and that it survived the court's inquiry into whether it was in fact a serious non-morality-based argument. So to those who say, well, my God, if you're going to grant access to civil marriage to same-sex couples, why not polygamous couples? Why not plural marriages? They're separate questions. It is conceivable that a society has a very credible case for not institutionalizing polygamous marriages. The fact that it, in my judgment, doesn't have a credible case for not denying access to civil marriage to same-sex couples doesn't mean it doesn't have a credible case for refusing to countenance polygamous marriages. It's a separate issue. Look at the arguments, make your judgment on those arguments, as the Canadian court did.
Thank you so much for this vindicating your reputation as one of our great teachers on these fundamental questions of law, religion, and morality, faith, freedom, and family. Professor Perry, I think, has deserved a robust round of applause, and I think we should give him one.
The preceding program is copyrighted by Emory University.